How does a guardianship end? Hello, my name is Tim McCurdy, and I am a guardianship lawyer practicing in St. Louis, Missouri. How does a guardianship end? There are four basic ways that a guardianship can end. The first would be a guardianship for a child will end once the child turns 18. In Missouri, 18 is considered the legal age where you're no longer considered a child. You can make decisions on your own. So unless there is a petition to continue the guardianship because of incapacity for a special needs child, once that child turns 18, the guardianship will end. The guardianship will also end when the person passes away. If someone dies while under a guardianship, the guardian will have certain limited powers to make arrangements for the funeral, but otherwise the guardianship will end. This can be significant if there is an estate. If the individual has ownership of any property, the conservator may not be able to dispose of that. It may be necessary to open up a probate estate to manage the estate of the person who passed away, because the guardianship powers will have ended when that person passes away. A guardian can also resign from that position. Keep in mind, though, that when a guardianship is appointed, it is because the court has determined that either the parents of the child are unable to serve as the natural guardians of the child, or that an adult is incapacitated and cannot make decisions for him or herself. So unless there's evidence that that has changed, the court is only going to allow the guardian to resign if someone else is able to serve in that capacity. So oftentimes a guardianship resignation, or a guardian seeking resignation, will be combined with someone else seeking appointment so that the court knows someone is still taking care of the person. And then finally, a guardianship can end by court order. So when would a court order the end of a guardianship? One example would be for a conservator would be if the estate is exhausted. The conservator is someone whose only job is to manage the finances for the person. So if there are no longer any finances to manage, then the conservatorship isn't necessary, and the court would end the conservatorship even if a guardianship would continue. There can also be a petition to end the guardianship. This could be for a child. It could be the parents who are petitioning the court, saying that circumstances have changed. The parents are now able to serve as the natural guardians of the child. Although they will have the burden of proving to the court, this is what's changed, this is why they're now able to care for the child. Or if it's an adult, it could be a petition arguing that that person is no longer incapacitated, and therefore the guardianship can and should end. Now, unless that's something that is being consented to by all involved, the court will likely require a hearing and medical evidence to decide whether or not that guardianship is still necessary. Also, the guardianship could end if the guardianship can no longer perform his or her duties. And one way to think about that would be that the guardian only has powers in Missouri. So what if for some reason the person has been moved out of state? The guardianship can no longer continue because the person is no longer in Missouri. Now, the court can also modify the guardianship powers and provisions. Once the guardianship is appointed, the court still maintains jurisdiction over the guardianship and has essentially oversight powers and duties as a part of the guardianship. So someone can come to court and seek a modification of the court order in terms of the powers of the guardianship. They can change the scope for the guardian, say perhaps the individual has improved in some way to where what was a full guardianship can now become a limited guardianship. Or it could go the other way, and if, say, a limited guardianship was in place, unfortunately the person has, maybe their dementia has progressed to the point where now it really has to be a full guardianship. It can also change the guardian. It could be the resignation of the guardian, as we mentioned, being replaced by someone else, or it could be someone else coming forward and saying that they should be the guardian for this individual. So that could be an allegation that the guardian has failed to perform his or her duties, or it could simply be someone coming forward who's a close family member and saying that they should be appointed over, for example, the public administrator. So those are circumstances where the court might modify the guardianship, even though the guardianship itself will continue. Keep in mind, though, that without one of these circumstances that will either end the guardianship or modify the guardianship. Once entered, the guardianship will continue. I hope you found this information to be useful. Please keep in mind that this is general information and should not be relied upon solely to make legal conclusions based on your own unique circumstances. If you have questions about guardianship, please feel free to contact me, and I would be happy to help you in any way that I can. Thank you.